for the medal here. On the matter of the People's State of Michigan versus Todd Courser, case number 16-1385.
Good morning, Your Honor. For the record, Gregory Townsend, Assistant Attorney General on behalf of the People's State of Michigan.
Good morning, Your Honor. Assistant Attorney General Denise Hart on behalf of the people.
Thank you.
Matthew DiPerno on behalf of Todd Courser.
Thank you. This is people's motion for protective order, so I thoroughly read the motion and response, so hopefully we can keep the arguments limited to the items that are requested to be protected. The content was to be protected, and the defendant's position on why it should not be protected without disclosing the actual contents of the information sought to be protected.
Very well, Your Honor. I do want to limit my argument solely to our motion and keep it within the confines of that. I would just let the court know that I am ready and I am able to address any other issues that were in response. But I'm going to maintain my motion. Back in May of 2016, Judge Clark ordered a protective order. It was signed by all parties. Myself, the counsel for at that point in time, Counsel Gamrat, and also Mr. DiPerno personally signed this. At that hearing, Judge, and I'm sure you can understand the preliminary examination, that the jury box was full of media. There's newspapers throughout the entire courtroom. Discussions on this was held at the bench, which the panel was present at that time when the discussions were had. And as the order says, the order that people's motion for protective order is granted, and that the state of Michigan House of Representatives audio tapes identified in the record will be subject to a protective order of this court, meaning that the identified audio tapes are sealed by the order of the court and shall not be disseminated or released publicly, either in whole or in part. I would indicate to the court, Your Honor, as far as the publishing, putting transcripts of the discussions of those audio tapes into a pleading is a public publication. Obviously, it becomes open once it's filed with the court. We addressed basically the same issue, Judge, with the County Circuit Court, basically on the same motion and the same arguments. And I would indicate to the court, and I do have a copy of the transcript of the court, if the court wishes to have a copy of the transcript. Judge Collette indicated to the court, well, all right. Court orders that any documents in this case that contain any reference to the state police investigation tapes are hereby to be sealed. It does appear that because the defense has chosen to place numerous parts of the use to numerous places on the record, that the entire file prior to today will be sealed except for appellate and other purposes by other courts. So will not be made publicly available. That is my ruling. He further indicated early on, and he's holding off whether or not to find the defense counsel in contempt of court on that matter. I would indicate the sealing of the records and the sealing of the tapes and the transcripts is not that the court can't see these transcripts or that counsel can't see these transcripts. It was sealed so they would not have be available publicly by the public. For this reason, Your Honor, we are just simply asking the court for protective order to enforce Judge Clark's order that was entered back in May of 2016.
Mr. DiPerno.
Thank you. I did sign the protective order back with Mr. Clark, but I signed it as the form only if you look at that order, because I didn't agree with the request made. But what was discussed at the bench was that the prosecutors needed time, they said, to review certain audio tapes for privileged information. But there's never been any objection to any privileged information. But nevertheless, I think this is simple, very simple on its face, because the order says that the tapes that are protected are, quote, the State of Michigan House of Representatives audio tapes identified on the record. There are no tapes at all identified on the record. None. Zero. And the prosecutors cannot point to one single line on any page in the transcripts where they identified any audio tape on the record. So how can this court enforce the order of Judge Clark if there's nothing identified on the record? This court would have no way to know what Judge Clark meant by the state of Michigan House of Representative audio tapes. No way, no possible way for the court to understand even what Judge Clark was thinking in that respect. Because the only thing you can do would be look to the transcript to see what was identified on the record. Nothing was identified on the record. Second, there's two sets of tapes that we've been talking about. Tapes that the defense refers to as the police tapes. These are the tapes that I have attached to transcripts. These are the tapes that the state of police made in their investigation. For instance, these are tapes that where the state investigator said in those tapes, he says he acknowledges that there's nothing criminal that they found in this investigation, and then he says, but if the attorney,
I guess that's like limited to the nature of the tapes as opposed to the content.
what's that?
As opposed to whatever the tapes include, what is that you would like to have included as opposed to giving the content of tapes?
Well, what I'm saying is that
I read the brief, I understand that.
What I'm saying is I don't think there's anything. What I'm saying is that these are tapes made by the state of Michigan Police. That I think that's what they're trying to now get a protective order for. What they refer to as the state of Michigan House of Representative audio tapes, we have always referred to as the police tapes. They were made by police. But there are, we believe, a set of House of Representative audio tapes. And during the discussion with Judge Clark, he came back on the record and he said, okay, for the record, the parties, he said, for the record, there's going to be a protective order. The people will propose a protective order and I'll sign it. And he says, anything else? And he asks me if I had anything else. He asked Mr. Townsend first if he had anything else. He said no. He asked me if I had anything else. And I said yes. I said, as a preliminary matter, yesterday I received from the Attorney General's office several hundred pages of documents previously requested. And I said, I've been promised a disc with some additional recordings on it. And those are the tapes that we were promised. These are tapes that we still never have received. These are tapes that we identified in discovery requests and letters to the AG as tapes made by the House of Representatives, which we've never received. But we acknowledged on the record that those tapes exist. They didn't say that they didn't. They actually promised them to us. They didn't stand up and object at that point and say, what is he talking about? So there's two sets of tapes, and I think that's important. But I cannot see how the court could ever enforce an order by Judge Clark when you don't have any idea what anyone is talking about because nothing's identified on the record. We're saying on one hand that there's other tapes. There's tapes made by the House of Representatives. They're saying that it's these tapes, these state of Michigan police tapes. You would have no way to know which it is. So that gets to the next point. Let's assume we get past that and the court says, you're right, Mr. DePerno, there's no way I can determine which tapes Judge Clark was referring to because no one actually went and put anything on the record. The next question is, what else is the AG's asking for? Well, what they're asking for, I think, is just a protective order now. At this point, they're saying, now, Judge, you can grant a protective order. But in their motion, a page and a half, no case law, no authority, no statutes, no court rules, nothing that gives you any authority to grant a protective order in these in this case as to these tapes that they're talking about. And I say that because I've looked. I have found absolutely no authority for this court to grant such a protective order. If you did do so, I believe that number one, there'd be a violation of the defendant's First Amendment rights. He has a right to, if he wanted to publish these tapes, to defend himself. The state of Michigan has never had a problem at all putting things on their website, publishing whatever they wanted about Todd Corser, but now that there's tapes, they're that are absolutely damaging to the prosecution, to the defense, to Bill Schuette, and the state of Michigan. These they want protected, apparently. They don't want the public to know about the tapes that were recorded by the state of Michigan police, and they don't want the public to know what the state of Michigan said about the investigation. And how do you do that? Are you going to protect the state's interest over that of the defendant's interest? And on what basis? What would be the rationale to say, I need to protect the state's interest over that of the defendant? What are we protecting? Why do they even have an interest in anything being protected? It's the state of Michigan. It's their own investigators. This is what they did. It's recorded. Why does the public not get to know about that? I mean, I think the court would have to do some balancing test as to the state's interest versus that of the public's interest to know. And certainly the public would have a right to know how the state has chosen to spend taxpayer money on this prosecution, knowing what the police have already said during the investigation. One final point, Your Honor. They raised this issue about Judge Collette, that he already granted their motion in King County. He did do that. He's now been disqualified from the case. We filed a motion to disqualify him. He was biased. He is now admitted in a newspaper article to being biased. He's now admitted in a newspaper article that, yes, he did have meetings with the prosecutors outside my presence. That happened. It's now an admission on the record in the paper. His order, none of his orders are going to stand up in the end once we file motions for rehearing. I don't even know why they bring that up to you, why they think that's relevant, but if I don't think it's appropriate to get into all that here, but Judge Collette's orders are not going to stand up. This court should put no weight on those orders at all. And so for those reasons, as I've cited, I think this motion is entirely frivolous. You cannot ask a court to enforce an order to protect tapes identified on the record when they themselves failed to identify those tapes. And for that, I request that we get our sanctions, attorney fees, my travel time, and time for preparing for this motion. Thank you.
May I respond, Judge? Sure. First of all, this is one of the reasons I think Judge Collette refused to have any bench conferences with the defendant. Everything would have to be on the record if the court would read the transcript. Because he has his memory of things that transpire at the bench, he seems not to recollect. He was there, he knows exactly who we were talking about. The reason it wasn't placed on the record is because there was all the media present. And for that reason, Judge Clark formed the order in the manner that he did. He knows the bench conference was had discussing the reasons why they had to be sealed and not put on the record. He knows that two of the House employees were attorneys representing the House. Information, and that information is privileged information, attorney-client information, reasons for the protective order of those specific transcripts. He has the transcripts, he has the information. It's not as if he can't use it during the court, during the trial proceeding. Of course he can. It's just for, at this point in time, not for public viewing. I was waiting, and I expected he would do this attacking Judge Collette. I would indicate Judge Collette did disqualify himself, indicating that he couldn't in good conscience remain on the case. And the reason of that is because of the behavior of Mr. DePerno. If I can just for the court, and I wasn't going to bring it up, Mr. DePerno brought it up. And Mr. DePerno, you have an amazing ability to either forget, misrepresent, or out and out lie. Because everybody on my bench, including the court order, and I think my clerk, I didn't answer, but we all heard what you initially said. I must say in absolute amazement, that any member of the bar could lie and misrepresent in the manner that you did on this record. It was despicable, it was not the right word. It was unethical and in violation of the rules of conduct. Gives you an idea of what Judge Collette had been going through. And I won't belabor, I was going to argue a lot more, I'll just leave it at that. There is a court order by Judge Clark. Same argument, Judge Collette saw it, ordered that it be protected. We just asked the court to continue the protective order in this case. And that was dedicated his response. The defendant again violated the court order by including some of those transcripts.
Your Honor, if there's a privilege they want to identify, like you just said, then narrowly identify what it is. Tell the court what the privilege is. But we can't protect the state from their own words in a criminal case. They don't want the public to know what their own investigators said. It's ridiculous, really. Thank you.
I won't.
All right, the court rule, not cited by either party, involving discovery, 6.201C, prohibited discovery, 6.201C1 says, notwithstanding any other provision of this rule, there is no right to discover information or evidence that is protected from disclosure by Constitution, statute, or privilege, including information or evidence protected by a defendant's right against self-incrimination. Paragraph E, protective orders on motion and showing of good cause, the court may enter an appropriate protective order. In considering whether good cause exists, the court shall consider the party's interest in a fair trial, the risk to any person of harm, undue annoyance, intimidation, embarrassment, or threats, the risk that evidence will be fabricated, and the need for secrecy regarding the identity of informants or other law enforcement matters. I have not heard any of those arguments in the record here in this court. In addition, the court does note that Commissioner Rule Professional Conduct 3.6 controls the ethical public dissemination of any information with respect to a case prior to trial. And given court rule and the arguments have been made, I'm denying the people's motion. Anything else?
Are you denying our request for sanctions?
I don't find the motion to be frivolous. I'm denying the request for sanctions.
I'll prepare the order.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Oh, it really worked. Yeah, it's cool.
There's that request for
Hey, Wayne.
yeah.